Good afternoon, everyone. Those of you who don't know us, I'm Aaron, Brendan, to our webinar. So we've been doing the presentation we're about to do for you today. We've been doing around the state now for the last 3 weeks or so. We've just finished I guess, the live sessions, and so we're now syndicating this, if you like, via the webinar for those of you who missed it. Brendan and I normally do these together. I think we only managed to do one together this time around due to sickness and travel and all sorts of stuff we had on. So this is the first time we're doing it together. We'll try and keep it pretty conversational. Without any further ado, I might just share the screen and we'll get started.
Just to add, there's a questions Q&A sort of box on the side of your screen. If you have any questions as you go along, just type them in and we'll probably just answer them as they come in.
Yeah.
As we go.
If we can, we'll interrupt what we're doing and speak to you. And if you see us looking down and to the left, it's because we're reading your questions. So look, I'll start and I'll hand over to Brendan about halfway through, but we'll probably just jump in and talk as we're going along. As I say, keep it conversational. So those of you who have attended our in-person presentations in the past will know that when we get to this time of year, we do a year in review. It's a little bit lighter. We keep it to some case studies and some more fun topics, I guess. It's always fun to go through some war stories, and we try and keep those war stories kind of relevant to things that are currently going on in the insolvency marketplace, which is exactly what we've done today. But before we do that, we just need to give you a quick disclaimer. So everything we say here today, of course, is by way of general comment. If you need advice, we're only too happy to help you out with some advice afterwards. Just contact us. Our contact details will be on the slide at the end here if you don't already have them. Before we sort of get into the case studies, though, we've got a little bit of data. It's some data that comes out of our, I guess, our database here at Worrells, and it's some of the work that we've done over the last 12 months. To put it in context, it is statistically significant data. We make up about 8 or 9% of all insolvency appointments across our sort of group of firms nationally. So the data that we have is fairly representative of what's going on out there in the broader marketplace. Coming off a couple of very quiet years, we've seen a real increase in the number of formal insolvency appointments in the last 12 months. We've had 475 creditors voluntary liquidations. There's been 111 members voluntary liquidations, which is quite a high number. 89 bankruptcies, which is an exceptionally low number. I reckon I've had years where I've done more than 89 bankruptcies on my own, and that's what we've done as a firm. Bankruptcies at the moment, and you might have heard us talk about this in previous presentations, the number of personal insolvency appointments is very low. What we're starting to see at the moment, it's anecdotal at this stage, but I think we'll see reflected in the data over the next 3 to 6 months, an increase in the number of personal insolvency appointments. We're really starting to see a lot more inquiry and some more appointments beginning to come through. The next one there, 38 voluntary administrations, 18 of which proceeded to a deed of company arrangement. That 18 going to deed of company arrangement is quite a high number. I think historically there's something like only about 9% or something like that of voluntary administrations which go through to a deed. And the fact that we've had about 50% over the last 12 months is quite telling. And I think that perhaps reflects the ATO's position on small business restructuring and helping businesses out generally to restructure. Previously, the ATO has not been prepared to compromise core tax debt, and we would often see them voting against voluntary deed of company arrangement proposals on that basis, as well as for other reasons. But at the moment, they have a public policy position where they will support companies, small businesses, to restructure by compromising their core tax debt if it's done through either voluntary administration or small business restructuring or personal insolvency agreements, which we'll talk about shortly as well. The statutory trustee appointments. So these are we've got a case study coming up on one of those soon. So 8 and about 5 of those have come out of our office here in Parramatta. So we've been quite busy with those in the last 12 months. And we've had 9 personal insolvency agreements, and again, a couple of those out of our office. Small business restructuring. So this is the new appointment type, which was introduced as a response to COVID. There were very low numbers generally in the first 18 months, I guess, after it was introduced in January 2021. You see there that in total since January 2021 at Worrells, we've done 134 of those. But importantly, this calendar year, or the calendar year up until we did these this data, which was 10 months, which had 74 and plenty more since as well. So we're really starting to see an uptake in the number of small business restructurings. Recent conversation I had with the ATO, they indicated that in July they'd seen 100 new SBR appointments. August they'd seen 200, and September they'd seen 400. So it's really starting to go up across the board, and we've seen the ATO has been excellent, I have to say, in the way they've set their policies around SBRs and been responsive to us. But we've seen, because they're getting so busy, we've seen a real drop off in their capacity to respond and discuss with us proactively. That being said, we're still getting really good results, and you can see there we've had a 97% success rate across the board so far in our team, 100% success rate. That is quite high. It compares favourably to the market in general, but it's not substantially higher. I think last official data I saw was about 92% success rate generally. So when you consider the ATO as the primary creditor in all of these, it really shows that they are happy to do deals to help small businesses restructure coming out of COVID. So, total dividends paid to creditors in 2023. This number, I think, reflects the type of work we've really been doing over the last 2 to 3 years. The insolvency market really slowed down as a result of COVID. The sorts of appointments we got predominantly over that period were the zombie company type appointments. There were no assets, small amount of liabilities generally, and sort of fixed fee engagement type ones. So we weren't doing a lot of asset realisation and therefore not paying large dividends to creditors in the current financial year. It hazard a guess that on a normal year, most of our partners across the firm would pay that much out. But yeah, so that's a relatively low number, but reflects the type of work that's been going on over the last few years.
And just a lower volume of work.
Yeah.
Just less appointments, and it's often 18 months plus to get to the point where you pay a dividend. And so, the 18 months, 2 years ago, there was less work coming in, so there's less dividends now. That number will jump up as the current appointments, which are back to sort of normal levels, flow through that process.
Yeah, great. And so I guess what we'll be looking at today then in terms of the war stories that we've got for you. So we've picked a few jobs that kind of reflect a lot of that, what's going on in that data. So we're going to look at a small business restructuring, and we're calling it an SBR with a lot. Honestly, everything that could be dealt with in an SBR was dealt with in this particular matter, and quite successfully. And then the matter of ClayPave, so that's a bit of a larger job, longer term appointment, which resulted in payment in full for all creditors. So that was just kind of like an orderly shutdown of a business through an external appointment. The 2 cafes, one big problem. So this is a personal insolvency agreement. So a personal insolvency matter is very similar sort of outcome to what we've been getting through small business restructuring, which shows that it's not just companies that can benefit from there's small bit, well, from a restructure, there are ways that we can achieve this for individuals, sole traders, partnerships, that sort of thing. And then also finally a tale of two, so two angry brothers, two cats and some fish. And that's a bit of a, it's one of these statutory trustee appointment matters, again, with all the typical issues we expect to see on those. So we'll start off with an SBR with a lot, and this is, well, at the time we authored this paper, this was our most recent SBR. We've had a few since, but this is a successful one. And just by way of background, this is a company that had a checkered history with the ATO, and as we all know, the ATO doesn't like supporting companies that have a poor lodgement history. It doesn't want to help bad taxpayers to make the same mistakes over and over again, resulting in more losses. In this case, this company had been into liquidation once before, back in 2015, on an ATO wind-up application. All creditors got paid in full back then, and it came out of liquidation. It's fair to say that the director, I think, was pretty frustrated with the world following that, and that it cost him a lot of money. Won't go into the details of why, but there's a fair bit went on back then. And he got behind again on his lodgements and was frustrated with his accountant, didn't want to work with his accountant, annoyed with the ATO, and just, despite making a lot of his regular contributions towards tax liabilities, wasn't doing all of his lodgements and got behind again. Having seen the error of his ways and coming out of COVID and moving into a period of some good work, found himself a new accountant, made some changes to his business, to his processes, got all of his returns up to date, lodged about 18 months worth of BAS, and then was pretty much straight away hit with a new set of wind-up proceedings from the ATO. And we've seen that a bit lately. Companies are getting their act together, getting things up to date after a bit of prodding from the ATO, and then as soon as they sort of crystallise the debt and the ATO knows what the debt is, they're hitting them with direct penalty notices and wind-up proceedings and that sort of thing. So that's what happened with this company, and then I was introduced to the director by the new accountant. We started having a bit of a look at the company's financial position and financial performance. And it was clear that this was quite a good business which had the capacity to pay its debts, and in fact the director had intended to pay the ATO debt in full. He'd just really run out of time to do that and to make those arrangements because of the wind-up application. So we had to see what we could do to help him. So it was obvious that a small business restructuring appointment was possible. There is a history of this business having been impacted by COVID, as well as all of the recalcitrance in lodgements, it's fair to say. It had a bit of a suit debt there that it paid, but fundamentally it was a very good business, had good cash flow, costs were under control, it provided services to construction industry at, it would provide labour and services to do concrete pours. So basically they'd do 1,300 odd cubic metres on a good day. About 20 staff, and very good at what they do. Cash flow was excellent, as I said, and they didn't pay for any of the concrete that was going down. They simply provided the services. So any trade creditors they did have were all cash on delivery. So there was no trade debts accumulated or anything like that. The only creditors were a little bit of superannuation, which was paid out. It was only the current quarter, so they'd been good there. There was an ATO debt there of about $650,000 and a small amount owing to the Office of State Revenue, plus an iCare debt of $80,000. So in order to propose a deed of a small business restructuring, we needed some good information to, I guess, base a plan upon, and that required some cash flow analysis. Given the time of year that this occurred, which was towards the end of August, the company's accountant at the time was flat out and couldn't do the work, not in the time frame that was required at least. And so we actually did the cash flow projections for the company. We can do that in a small business restructuring engagement because we don't have the same independence requirements that we do for say a liquidation or a voluntary administration, because we're actually engaged by the company to represent the company to assist it to make the plan with its creditors. So we did the preparation work, prepared some cash flow statements, and we importantly stress tested those cash flow statements. And that showed that, look, there really was some good work coming up. There was a lot of contracts coming up over the next 12 months, and cash flow was expected to be good. There was also a fair bit in work in progress at the time we were appointed as well, which allowed for a fairly high initial contribution once that was converted from WIP into cash flow. The company had sufficient working capital sitting there in the bank account to cover the costs of that. So most of that WIP was cash flow that was available to immediately provide a return to the creditors. But what we did have to do was to get the ATO wind-up proceedings adjourned to give the company the time to go through this process. So Section 453S of the Corporations Act provides that, where there's a small business restructuring advisor appointed, then the court should adjourn that. Well, a creditor cannot pursue those ongoing proceedings, and so the court will, in most circumstances, then adjourn the proceedings for a period of time to work out what the outcome of the small business restructuring appointment is. If that results in a plan being entered into, then there's no ongoing need for those wind-up proceedings. Otherwise, the petitioning creditor can wind up if it fails. So the company needed to engage a solicitor, which it did, and through just agreement with the ATO solicitors, there was an adjournment of those wind-up proceedings. So we did a lot of work over the next 4 weeks to put together the plan. We sent through a draft plan to the ATO. Right at the last minute, the ATO came back to us and said, hey, we need to, the amount of debt is incorrect. It was out by about $40,000 from memory. So we had to issue another report to creditors to notify them of the difference that would make in terms of return. And that meant that we needed to extend, because that came through at the last minute, we needed to find some more time for the creditors to vote. Now, Regulation 5.3b.17 of the Corporations Regulations allows us to extend the period of the restructuring process by up to 10 business days. That has to be done upon the application of the company. So I contacted the director, said, hey, send me an email requesting this. We extended it by 10 business days to give creditors a chance to properly consider everything and vote. The impact of that, of course, was that then we needed more time on our adjournment of the ATO wind-up proceedings. So company solicitor negotiated that, and the ATO solicitors and the court agreed to a further adjournment of those proceedings. Ultimately, we issued the plan. We had some really strong engagement with the ATO. They were, as you may appreciate, quite reluctant on this one, given the company's history of poor lodgement and its history of having been wound up once before by the ATO for recalcitrance in lodgement and payment of taxes. And so they were quite reluctant to support this company. We were able to make a good case for the fact that it should be supported. We were able to demonstrate what had changed, bringing on of a permanent bookkeeper, the engagement of a new accountant, and albeit a short history of improved practices in that respect. We were able to show that there was a better return to creditors through small business restructuring, and that nexus to COVID downturn, which was important as well. And I think Brendan spent almost a full day talking to the ATO, and we had to give them a lot of information. What's interesting is they're seeking a lot of information now, data directly from the company's accounts, and one thing they ask us for quite regularly is the director loan account data. They want to see, they're very interested in what's going on with Division 7A loan accounts and those sorts of things to see what monies that the directors might or shareholders might have been drawing out of the company that might have contributed to their financial position. That could mean as well that they might start to be interested in imposing Division 7A penalties. I don't know, but they're certainly asking for all the information they would require to do that.
And it's very almost a prerequisite if there's a loan account where a director or shareholder owes money to the company, that the ATO wants to see that repaid as a prerequisite to considering anything else.
Yeah. This company didn't actually have any director loan accounts. There were loan accounts or transactions to loan accounts in the records where the bookkeeper was attributing certain transactions to loan accounts that weren't able to be explained, but the accountant on reviewing those had dealt with them appropriately, and so that meant there was no loan account balance, but there was some explanation that was required there in this particular case. But look, in summary, all three creditors supported the restructuring plan. At the end of the day, the ATO was about 85% of the total creditor pool, so it was really their vote that was always going to decide it. They supported it. Those proceedings were withdrawn. The company is trading profitably and in fact is doing so well on its payment terms on the plan that it's about 3 or 4 months ahead as we speak today on the contributions that are required. So so far so good, a successful outcome. All right, I might hand over to Brendan now.
Before we roll on, we've got one question. Is there a public register of approved arrangements and the circumstances leading there to assume by arrangements mean restructuring plans? And there's no public register. When a company enters into restructuring, they do get the little XAD notation on the ASIC register, and then the plan, when it's approved, gets lodged with ASIC, so you can go get it for that particular company. But there's sort of no central repository. You'd have to dig through the insolvency notices and then do individual searches on each entity to put that kind of information together.
ASIC is keeping data and publishing data based on those lodgements, though, so you can get some ASIC data on it, though it's never.
ASIC's done one report on SBRs. It was early in the piece. I think there'd been about 110 or so done when they did that, and we're at almost 800 now. So how representative that is a bit of a question because it's just so out of date. So we'll talk about this one, Claypave, case study with successful liquidation. So Claypave started its operations in the 1880s, so it's quite an old family business. And by the time we got involved, it was 3rd and 4th generation running the business. But the grandparent was still involved as a shareholder, and he was a bit of an impediment to the business moving forward. So we wanted to keep things traditional. The business had run into some significant profitability issues due to changes in the market that they just hadn't adapted to. The business made traditional kiln-fired clay pavers, so they were quite an expensive product. I mean, they're handmade in Australia, so it's not cheap. And overseas competition had really started to eat into them, and also just cheaper concrete pavers and the like. And then just generally pavers have become less popular. So the demand for pavers has fallen away. People are moving to smaller blocks, people are moving to more apartment living, there's less demand for pavers in those situations. And the business just hadn't been able to adapt to those market changes. And one of the key issues that they really had run into and not been able to deal with is staffing. So they were overstaffed at the time we got involved. As often happens with these long-running family businesses, the staff are part of the family almost. It's the son of someone who's been employed, and so for the family to terminate those employees was very difficult for them, because it was like terminating a member of your family. And the EBA for the group, so they had an enterprise bargaining agreement with their employees, which was incredibly generous. And an example of that is that it paid out staff for all their sick leave entitlements when they left, which is very unusual. The company originally went into voluntary administration off the back of the directors, and that was mainly an administrative choice, because there was a lot of various family members who were shareholders, and getting them all together to get a vote to put the company directly into liquidation was just going to be administratively difficult. Whereas with a VA, you just have the directors pass a resolution and it goes straight into VA. No deed of company was proposed, so then rolled into liquidation. It was just a more efficient way to get the company into liquidation. So the position at the time we were appointed was not great. The company had about 20 grand of cash left. It owed the bank $5.5 million. Had outstanding superannuation of $150,000. There were accrued leave entitlements of $1 million, and that included about 100 grand of those sick leave entitlements, and then $450,000 of unsecured debts. So that doesn't look very good. And on a cash flow basis, this business was very insolvent. It just was unable to continue to pay its ongoing costs to be able to continue to trade. But it had a lot of assets. It had a property, a huge amount of plant and equipment, it had a lot of stock because they've been stockpiling stock. They've got too many staff. They just keep producing and stockpiling the stock. And so it had assets there. It wasn't hopelessly insolvent. It just was temporarily insolvent while it dealt with this cash flow crunch that it had. And that was really the reason for the appointment. The temporary insolvency, or the short-term insolvency they had, was the reason to bring someone externally. The directors, in particular, the younger generation, weren't particularly interested in this business anymore. The older generation had started it, it was their baby, and it had been passed down. But as often happens again with these long-running family businesses, by the time you get to the fourth or fifth generation, those people want to go off and do something else. They don't want to continue the family business. And so they didn't really want to deal with the process of winding the business down. The second benefit of the appointment is you can compartmentalise those pre-appointment debts. So if you continue to trade in the ordinary course, you've got to deal with the bank, you've got to deal with the 450 grand worth of unsecured creditors, trade creditors, and you've got to deal with the outstanding super, because the ATO is very aggressive about making sure the super gets paid. Whereas if we put it into administration, we get breathing room, because all those debts are put to the side. They're in abeyance until we go through the process, and that gives us breathing space to do an orderly wind up of the business, maximise the value for everybody. So step one, getting into this business, was right sizing, which is a terrible term, terrible corporate term, but it applies often in these kind of turnarounds because they just have too many staff. And so we needed to reduce the workforce. And again, we have the benefit that in insolvency that they didn't have. One of the problems they had making people redundant is you need the cash there to pay the people their redundancy. And when there's $1 million worth of leave accrued, it can be very expensive even to get rid of a few people. Whereas in an insolvency situation, we can make people redundant and again, put those entitlements in abeyance, and either they have to wait until there's a dividend, or once the company goes into liquidation, the Fair Entitlements Guarantee Scheme, which is a government scheme that guarantees employee entitlements, comes in and pays them out, and then we reimburse FEG later on down the line when we have the money. And so once again, we can have the flexibility to do things that wouldn't be able to be done in the ordinary course of business. We then went into a wind down phase, and so that's where we continue to trade the business, but with a view to winding it up. So we're offering discounts on stock to clear out the stock. And you still get a much better return in that situation than if we go to what we call a forced liquidation sale. So if we just shut the business and put everything up for auction on a Grays or a Pickles or something, we're going to get maybe 5 cents in the dollar if we're really lucky on that stuff. It just doesn't sell well at auction in bulk. But if we can continue trading in the ordinary course, do some 20% off and then 30% off and then 50% off sales, you get a much better return for that stock. And they also had stockpiles of dirt, which was the high-grade clay that they used to make the pavers. And that clay had very little value as a pile of dirt, but a lot of value if we took the time to convert it into pavers and sell those pavers. And given we're trading on, we've got a period of time to do that. We can get the people we retained to convert that clay and get a much better return for it. Once we'd wound down the business, next step was to sell all the equipment on the property, get through all the plant and equipment, do an auction, get all that sold off. And then finally, we're realising the property. So the business owned the site it lived on. And there are a couple of issues around realising the property that need to be dealt with. In particular, environmental protection type issues. So long-term industrial properties often come with environmental issues. And if the EPA comes in and makes an order and you've purchased that property, you as the current owner are liable for the cleanup costs, for the rectification costs of whatever the issues are. So if there's been contamination of property, then that can often run into millions of dollars of liabilities. And so what we did is get an environmental expert to come in, review the property and work out what kind of risks there might be so that we could give potential purchasers a clear indication of what the risks are if they decide to purchase this property. And that results in a better outcome because it takes away that uncertainty. If you're coming in to buy a property and this property sold for $7 million is serious, significant value, if you're coming in to buy a property for $7 million and you're concerned about $2 or $3 or $4 million worth of EPA risk, you're not going to offer that full $7 million. You're going to discount the price. Whereas if we can give you comfort by providing with this report that there's nothing wrong with the property, there were some minor issues that we undertook to clean up as part of the sale process, but otherwise it was clear. You get much better offers for the property. The other advantage of going to liquidation in this case was we were able to avoid liabilities associated with mining leases. So the company had some mining leases for mining clay. That's where they got their clay from. And those mining leases had a significant period to run. And ordinarily, when a liquidator comes in, we can disclaim a contract. So we can disclaim something like a lease. And that means we just hand the property back and we walk away from the lease. And in an ordinary circumstance with a commercial lease, that creates a liability for the loss of the landlord for the period from when we disclaim it to when they get a new person to come in. Because there's a period there where they didn't have a tenant where they otherwise would have. And so there's a claim there. But with mining leases, because there's no sort of tenant coming in, you can just disclaim them, hand them back, and the future liability just evaporates. And then the government has to resell the lease. And so there was a chunk of liability, it was about 120 grand of future liabilities that we could just make disappear by disclaiming those leases. So in the end, the property sold for $7 million, and then sales from trading on and the plant equipment equated to another $7 million. So we ended up with $14 million in total realizations for this one, which is a very decent chunk of money. So that was sufficient to pay out the bank in full. It was also enough to pay all the creditors in full. And then in a liquidation, if we have enough money to pay everyone in full and there's still money left over, we can pay interest from the date of our appointment until the date we pay the dividend. This whole process took a couple of years, so there was quite a significant amount of interest to be paid, a couple of $100,000. And then there was money left over for the directors and shareholders. It was about $4 million in the end that went back to the shareholders. And again, once we're in liquidation, we have to go to the court and get leave to pay a distribution to shareholders. So we've got to go to the court, and the court just confirms that we have paid everyone else who might be entitled to interest in the income of this company before we go and pay the rest of the money to members that made the application and got the money out to the shareholders. So looking at alternative options, so the directors did consider doing this process themselves, which is something they could have done. They could have continued to trade the business, wind it down like we did, sell the plant equipment off like we did. But the difficulty with they needed to cash flow that process. So they needed to be able to continue to pay trade creditors through the process. They needed the money to pay redundancies as they terminated the employees. And they weren't able to get that money. So they talked to the bank, and the bank was willing to put money in, but only at a match with the shareholders. So the shareholders would have had to put an equal amount in. And the estimate for the cost was going to be about $1.5 million. So they would put 750 grand of their own money in to get a deal with the bank. And they didn't want to put that money in. They also lacked some of the expertise and the connections that we have around selling property, especially around the environmental issues around selling this kind of property, and the connections we have with selling the plant equipment, which would have been more difficult for them. And also, it's just the peace of mind thing. They really didn't want to deal with this anymore. It had all become too hard. They weren't interested. Now they wanted to go do something else with their lives, and so this gave them the freedom to hand it over to someone and walk away. If they continue to trade it as well, they also expose themselves to potential claims like director penalty notices and insolvent trading. So if they'd made the election to continue to trade the business at a loss, try and wind it down, it didn't work out, the company ended up being wound up, then there's a period there where they would have traded the company whilst insolvent, and they would have put themselves at risk for that as well. So the key takeaways on this one: the company doesn't have to be hopelessly insolvent to benefit from the insolvency process. There are different scenarios where you can use the insolvency process as just a smart way to wind down a business and give you the breathing space to go through a proper structured realization strategy to maximize the value that everyone gets out of the business. As I said, it can allow breathing space for realizations. Minimises the stress for directors. Now, they don't have to deal with this anymore. They hand it over to an expert, and that expert deals with it for them. And there are liquidations where everyone is paid. It doesn't happen very often. We maybe have 1 or 2 a year, but they do crop up.
Questions?
We'll keep going. Next one's 2 cafes with 1 big problem. This dealt with 2 cafes that were trading in the Hunter Valley in sort of central New South Wales, and they'd run into trading difficulties as a result of first COVID. So being the area they're in, a lot of tourism-driven revenue, and when COVID lockdowns came in, that revenue just dried up. A lot of local cafes didn't do too bad during COVID because people were stuck at home, but they still needed to get their coffee and they could walk around the corner to get it. But these kind of rural cafes who are out in the middle of nowhere and they really need that tourism traffic to drive their revenue weren't able to trade as well through COVID. And then they'd also have an issue with a relationship breakdown through the COVID period, which had left the operator as a sole trader, as the partnership dissolved, and on their own. And because they're a sole trader, they can't take advantage of something like small business restructuring or the voluntary administration process to deal with this debt. And they had a significant ATO debt. I think it was about 300 grand by the time we got involved. They tried to do a payment plan with the ATO, but there was just nothing that was viable for them that the ATO would accept. They couldn't afford a payment plan over the 18 months to 2 years that the ATO wanted. It's just too much money on a monthly basis for a business like this. Even though they were a profitable business, they're not profitable enough for that kind of.
Everyone's probably aware, but the ATO is not being anywhere near as easy to deal with on repayment plans as they were. They're back to business as normal pre-COVID in terms of repayment plans, and they've said as much publicly at some of the events that we go to, some of the industry events. They're just saying, look, they're not. Those COVID days are behind us. They're not interested in payment plans at all over 2 years, and they're very reluctant on anything over 12 months without significant payment up front. So
they're asking to see, we've heard stories of them asking to see, they want to see cash flow forecasts, they want to see financial statements, those kind of things to support the payment plan, which again is a lot more information they were asking for during the COVID period. And we've also heard recently of some accountants, the ATO sending accountants a list of their clients So sending out all your clients how much debt they currently each have and where they're up to in the debt correction process with each of those ones. So whether they're on a payment plan, whether they're sort of at the warning letter stage, DPN stage, and so on and so forth. We've heard from a couple of accountants who've received those lists from the ATO. I don't know if that's something ATO is going to do with every client or if it's just they're cherry picking certain people, but we have definitely seen those going out. Key with this, and it's important with a lot of these matters, is this business had no significant assets. It was a cash flow business. It's in leased premises. I mean, they do have a couple of coffee machines and some tables and chairs and that kind of stuff, but there's no significant asset to sell. If the business fails, all the cash that it can generate goes with it. So, is there a question?
There's a question here, actually. Let's address that. So it says, are there any suggestions for ATO to write off general interest charge? I have a client that was several years behind in tax lodgements. These have been brought up to date, partnership business. Clients have offered to pay core tax debt. Look, I think given that ATO is back to business as usual, that was always their practice historically. I think they'd be receptive to that in the right circumstances. Again, they don't like supporting recalcitrant lodgers and payers, but if there's a genuine reason, then you can.
But I have heard some stories. So again, during COVID, getting interest and penalties waived seemed to be quite simple, and that appears to have gotten a lot more difficult. We've had a couple of cases recently where the ATO has refused to waive interest and penalties. And they're going back to the old, public interest reason for that. The interest is the compensation to the taxpayer for you paying late, and the penalties are the incentive to give you an incentive to pay on time. And so, I'm not sure how long getting those things waived will be easy. I think they're probably going to go back to the point where it is what it is, and it's your responsibility to pay on time and lodge on time. And if you don't, that's the consequences. Yep.
And just a comment there as well regarding the debt list that you mentioned, Brendan, saying that they're not all that accurate. So maybe the case. Yep. I think maybe the more important takeaway is the way ATO's intent and collection processes are beginning to evolve.
So as I said, this business had $300,000 owing to the ATO. It had a $53,000 debt to the Office of State Revenue or Revenue New South Wales, and that's something we're seeing start to pop up a lot with businesses. So the JobSaver scheme, it was JobSaver, was administered by Office of State Revenue, and they administered it very, very poorly. And we're seeing lots of cases where people got overpaid, and Worrells was one of those cases. We got significantly overpaid. We ceased to qualify. We told them we ceased to qualify, and they just kept paying us, and we couldn't get them to stop. And it looks like that's happened to a lot of businesses. We've had a lot of inquiry around this, and now OSR is going back, reviewing what they've paid, and starting to chase businesses for the overpayments. And you can understand we're in the middle of COVID; these businesses are struggling. They use the money. I'm fairly certain a lot of them didn't realise that they were getting overpaid or they were being paid the wrong amount. There's one we dealt with recently where they claimed $1,600, I think it was a fortnight, and the Office of State Revenue was just paying them $16,000 a fortnight. So clearly there'd been a typo somewhere there. And then they had trade creditors of $44,000. So the solution in this case is what's known as Part 10 of the Bankruptcy Act. So Bankruptcy Act deals with individuals insolvency, and the main part of it is obviously making people bankrupt who can't pay their debts. But there's another section, which Part 10, which deals with personal insolvency agreements. And a personal insolvency agreement is a bit like a restructuring plan for a person. And it allows that person to negotiate with their creditors and enter into a formal binding deed that binds all your creditors for a compromise of your debts. And similar to the restructuring process that happens before we enter into a restructuring plan, with a personal insolvency agreement, you enter into a controlling trusteeship at the start, and that's a 30 business day period where there's a moratorium or freeze on all the creditors' claims so that we've got time to work with you or the individual who's owes the money and the creditors to try and reach an agreement. So the reason is you do a personal insolvency agreement is obviously you can get released from your debts, you get that moratorium period, and then you're almost certainly entering into a deed where you're paying less than the full amount. You're paying a proportion, and then usually in payments over time, or there's a contribution from a third party, or you're selling assets down to fund that proposal. It ensures a fair distribution of the assets because everyone participates pari passu, equally in the pool. Has to provide a higher dividend than would be available in bankruptcy. That's a regulatory position that AFSA or the regulator has taken. If you propose a Part 10 that's less than bankruptcy, it'll just get bounced by the Inspector General. Maintain their source of income. So with the personal insolvency agreement, you can continue, like in this case, you can continue to run your business and have that income continue to come in. Whereas if that person were to go bankrupt, those cafes would have to be shut because a trustee in bankruptcy would have an obligation to realise what assets are available. So they'd be selling the coffee machines and the tables and stuff to get what money they could for creditors, and that destroys the bankrupt's revenue stream. And you can avoid some of the restrictions of bankruptcy. So when you go bankrupt, there's a whole bunch of restrictions placed on you. Including things like there's restrictions on travel, there's restrictions on certain professions. You can't continue to do certain professions. Whereas once you're in a personal insolvency agreement, a lot of those restrictions don't apply. Some of them still do. Like a building license is a sticking point for a personal insolvency agreement. But there's a lot less restrictions, which means you're more likely to be able to continue trading on your business, continue earning your income, that kind of thing.
Typically a shorter term, to the extent those restrictions apply, typically a shorter term because you don't have a 3-year term of bankruptcy.
As well, yeah.
These are usually over in a few months.
I think two big downsides with a personal insolvency agreement as opposed to something like small business restructuring is the bar to get the personal insolvency agreement accepted is higher. So with a restructuring plan, it's just 50% in value, so you just need 50% of the dollars to vote in favour. With a personal insolvency agreement, we need what's called a special resolution, which is 75% in value and a majority number. So you need to get both if you've got a bunch of small creditors and one large one in a restructuring scenario, the one large one is enough. You just use the ATO to push the whole thing through. That doesn't work in these kind of scenarios. And if the majority does not accept the proposal, the most likely outcome is you'll be required to present a debtor's petition and go bankrupt. So the small business restructuring, the restructuring plan isn't accepted, the company just goes back to trading as normal, and then they can try something else. They might want to try voluntary administration, they might want to put the company into liquidation themselves, they might want to just try and trade out of it. They've got other options, whereas usually if a personal insolvency agreement isn't accepted, you have no other option, you're going bankrupt. So in this case, it was a $90,000 contribution that was proposed, payable over 2 years, so $45,000 a year. And the way we got to that was looking at the income from the cafe pre-COVID, which was sort of they're almost back to that level, discounting it by 20% as a sort of stress test, and then taking half of what's left. So it was on a stress test basis, it was going to make about 90 grand a year, so half for the owner, half to go for the contribution for the personal insolvency agreement. And that was going to be a 22.6% return to creditors, which is pretty good. Our fees for doing the whole process were $15,000 in trustee fees. So total cost to the proposer was $115,000, which is pretty good to get out of almost $400,000 worth of debt. The proposal was accepted by creditors, and there were 3 real key areas that push this through, and we talk about it here just because it highlights some of the changes, especially in the thinking of the ATO. And so the better return than bankruptcy, the return in bankruptcy was going to be nothing. There's very little in the way of return from the assets, and then the income that this person was going to earn going forward was not going to be sufficient for them to make income contributions. So there would have been no contributions over the period of bankruptcy, and by the time you take some trustees' costs out of the realisations, there would have been nothing left. The other things were that these were 2 regional businesses, and so there's the ATO took a public policy perspective that saving jobs in a regional area, which was 6 jobs, and then saving businesses in a regional area was important to them. I don't know, why the distinction between regional and metropolitan, but that was something that swung them, and we're seeing them take a more public policy approach to some of these, Part 10s and small business restructuring proposals, and even deed of company arrangement proposals at the moment, where they're looking not just at the cents in the dollar return, but they're looking at things like if employees lose their jobs and the Fair Entitlement Guarantee Scheme will have to pay them, then there's a cost to the Commonwealth over here that they can save. Whereas in the past, they wouldn't consider that. They'd just be looking at the cents in the dollar return. But they're looking at, okay, the Commonwealth's going to lose money over here, even though it makes more money over here, so we can even that up. We've had some NDIS businesses that we've dealt with where the return has not been particularly good, or they've had other issues, but the key consideration that helped get them across the line was the fact that these NDIS participants have a relationship with the provider, and that relationship can often be going on for a long time. It can be difficult to find a new relationship, and so the ATO is there's a public policy reason to support this to avoid disrupting the lives of all these NDIS participants. And so it's good to see the ATO taking into account these other things.
I think the other public policy element there as well is the rebound from COVID-19. ATO has taken a public liability position in terms of compromising core tax debt to assist businesses to recover from COVID-19. And in this case, in the SBR case we spoke about, I mean, that's a really, these are examples of them taking that position.
So we have another question.
Another question, which is, sorry, I've got a pop-up just come up over the top of it. What would the history of a successful or failed SBR affect the company's borrowing capacity? The company's borrowing capacity, I think it's a positive thing because it improves, well, it's positive and negative. The positive thing is it improves the company's financial position, which means its capacity to repay, its funding capacity in terms of repayment is better. There are some negative impacts in terms of the financial reporting. However, a company that doesn't take this step is probably going to end up with far worse financial reporting consequences.
While you're in the restructuring process, so the 4 to 6 weeks, it has a significant impact on credit rating. But what we're seeing is once they actually execute the restructuring plan, the credit rating bounces back to pretty much where it was before. So there's not much of a penalty, it seems, from a credit rating perspective for executing a restructuring plan. And then on the the financier side, we see some financiers are having an issue with it. So you've got some issues with some financiers, but in the cases we've seen where people have come out of restructuring and gone to either finance equipment, get cash flow type loans, renew their overdraft, those kind of things. They've been in every case they've been able to do it. They just might have had to go to somewhere different than they were before. Because I know some of the bigger providers, like the Westpacs and the NABs and those kind of things, make it a bit more difficult. If you go to the second tier type, more flexible lenders who understand the process a bit better and a bit more involved in in the small business lending space, we're seeing them manage to get approval.
It's similar for the directors as well, insofar as they're having the same sort of feedback. You've had a history of a company that's gone through a small business restructuring. They're not necessarily qualifying for the lowest interest rate loans, but we've seen directors come straight out of small business restructuring and go and get a mortgage to buy a new property. So whilst it doesn't make it tougher, it certainly doesn't prevent future lending capacity or borrowing capacity.
All right, we're running out of time, so I'll do this one very quickly. Tale of 2 angry brothers, 2 cats, and some fish. It's a bit of a fun one to end off with. So this one involves 2 brothers. We're going to call them Tom and Jerry. Tom lived in a property. He really wanted to stay there. He had a good kick living in this property. And Jerry was the other co-owner of the property. And he wanted to sell it. He wanted to cash out his share. And the brothers had a pretty bad relationship. They haven't talked to each other for about 4 years, except through lawyers. They've been arguing about this property for a long time. And they haven't been able to reach an agreement. And so Jerry had gone off to court and asked the court to appoint a statutory trustee. And there's a remedy in each different state. It's a different legislation, but in Australia, in New South Wales, sorry, it's 66G of the Conveyancing Act, that allows a person who has an interest in a property who wants to realise that interest to go to court, and the court can force the other owners to sell if they don't avail themselves of one of the other options, like purchasing that person's interest in the property. In this case, Tom wasn't interested in doing anything reasonable, so the court made orders to have the property sold. The orders required Tom to vacate the property within 14 days of the court order, so he was to remove his stuff and get out. And importantly, any costs that were incurred by us doing this process were to be paid out of Tom's share. So looking at it, Tom had a big incentive to make this quick, smooth and cheap, because he was paying the costs if it got long and complicated and expensive. So it seemed like it would be pretty straightforward, and every single one of these, we go in, very positive, hopeful that it's going to be nice and straightforward, and they always invariably seem to be more difficult than we expected. In this case, it was, of course, more difficult than he expected. In particular, Tom, he refused to move out, so the 14 days expired. He said he wasn't leaving, didn't care about the court order. It was his house, and we could, take a flying jump. We issued him some notices to vacate, tried to get him out, and he just wasn't cooperative at all. And so we had to go up to court and ask the court to enforce the order to remove him. So that gives the court issues what's called a warrant for enforcement, which we then take to the sheriff, and the sheriff will set a date to enforce that order. And so what that means is we have a date, we go out there with the sheriff, usually some police. If it's a really exciting individual, we'll go to a lot of police. And the police and the sheriff will forcibly remove the person from the property and then hand the property over to us. In this case, it wasn't an exciting eviction because Tom and his partner were arrested the day before the warrant was to be executed. So on the day we went out there, they'd already been removed, helpfully, by the police for another matter. And we were able to just take possession, change the locks, and get control of the property. There are a couple of issues once we got access to the property. First, it was in a very bad state of disrepair. So the couple had 2 cats, and the cats had made a mess of the place. The place stunk. The carpet we had cat urine soaked into it, and it had actually soaked into the concrete under the carpet, which was a problem. And then the kitchen was pretty much destroyed. There were some holes in the walls. It was in a very bad state. We also had the 2 cats, and there was also a big fish tank full of fish in the property. And we obviously have an obligation to look after the welfare of those animals once we take possession of them. And so the cats in this case were sent to an RSPCA shelter that was nearby. And Tom's partner got released the next day and was able to go and collect her cats. The fish, however, there's not really anything we can do with those. So we had to make arrangements for someone to sort of attend the property every couple of days and feed these fish so they continue to survive. And then we have the issue of Tom's belongings. So all his stuff is in the property. The partner came and collected her stuff, but all his stuff's still there, and a lot of it's, not the best. It's kind of junk. But we can't just throw it away. In every state in around Australia, there's different rules for abandoned goods, but you have to go through a process to have goods declared abandoned so that you can destroy them. In New South Wales, it's the Uncollected Goods Act. It takes about 3 months to go through the process, and we don't want to wait 3 months until we sell this property. So we had all of his stuff removed and put into storage. And so there's additional costs now just racking up every week as we pay storage on all his stuff. The fish are obviously still there. We can't put the fish in a warehouse, so they're an ongoing problem. But we have a vacant house, and once it's vacant, you often see what a bad condition a house is in and how much work it needs to tidy it up. So we got some advice from some agents on this property, and they advised us very clearly we couldn't sell it in the state it was in. Given the smell, given the damage, we just put people off, and we'd be lucky to get enough money to pay off the mortgage, which is obviously not good because mortgage gets paid first, and there'd be nothing left for us, Tom or Jerry. So we had to get the property repaired. That process took about 6 months because in the post-COVID world, getting tradies is difficult, and we needed a range of different trades. We needed someone to do the kitchen, we needed a plumber, we needed an electrician, we needed the person to pull up the floors, and then they had the slab had to be disinfected so it didn't smell anymore, and then we had a new floor put in, and the whole thing had to be painted. And so bouncing between all those different contractors and trying to sync them up is very difficult at the moment because they're all sort of overworked and busy. And so the whole process took 6 months. It also cost about $25,000 to go through that process. And no one wanted to fund that for us. So the bank wasn't interested, neither Tom or Jerry were interested. And so we ended up funding that ourselves. And that happens a lot in these matters. There's no one to pay for these costs except us. So finally get the property all cleaned up. It's looking really good. It goes to market. We went through a sale program, and in July 2023, we finally got the property sold. And in the end, it was $740,000, so a bit more than we expected. There was 26 grand of rates, utilities, and other expenses that were unpaid on the property that had to be paid on settlement. $472,000 for the mortgage and another 18 grand for the agent for their marketing and commission. So we ended up with $224,000 in net proceeds, which should have been 112 grand each. If these two had just come to an agreement and sold the property themselves, they could have got 112 grand each. Instead, what actually happened is we spent $104,000 in repairs, removalists, legal costs, storage costs, all the things we had to do to get this property sold. And our fees ended up being $82,000. So in the end, there was only 38 grand available, and Jerry obviously got all of that. What should have happened is our fees, our expenses should have only been the 25 grand to repair the property. If Tom had moved out, been cooperative, we wouldn't have had all the additional legal costs and removalists and storage and all that stuff we incurred. Obviously the dam works was a sunk cost by the time we were appointed, so that would have had to be dealt with, but there would have been only 25 grand in costs, and we estimate our fees would have been $25,000. So if Tom had been cooperative and worked with us, he would have received $62,000 instead of nothing, and Jerry would have got an additional $74,000. But does the story end happily? Well, Tom eventually got released from incarceration. And he got released before we completed that uncollected goods process. So we still had his goods in storage, and he collected his belongings from storage and got to go away with all his stuff, didn't lose that stuff. And Jerry got his money. It wasn't as much as he expected or hoped, but it was still a bit of a windfall. It was better than nothing. And the key thing he wanted here was closure with his brother. He wanted to be done with the brother, and so now he could just walk away, never have anything to do with him again.
What we don't know though is whether the money he did get was enough to pay his legal fees. And then the fish. So during this whole process, when we're having the property renovated and work done, the fish was still in the property, and we were getting the contractors to feed the fish for us. It saved someone from our office going out there all the time to feed the fish. And in particular, the painter, who was in and out quite a lot because he had to fit in around other people, he took a liking to the fish. And in the end, he took the fish in exchange for a bit of a discount on his invoice. So the fish found a loving home with someone who really cares about them. So it's a good outcome for the fish in the end. They were the real winners in this whole thing. Any other questions? I don't think we do. Any questions?
A bit over time anyway. Before we wrap up, just wanted to announce another CPD offering that we're adding to what we do next year. So we'll still be doing all the normal stuff, our breakfast and lunch seminars, our mid-year day conferences, these webinars, our national webinars, all that stuff will continue. But we're adding on a particular CPD tax series. So it'll be 11 monthly sessions starting in February. It's all complimentary, like all of our other offerings. And we're offering this because talking to, in particular, our accountant referrers, the people we work with, we've had a lot of feedback that getting good tax CPD can be expensive. And so we've partnered up with Webb Martin, who are a tax consulting business down in Melbourne, to offer these. So you can scan the QR code on the screen to register for the whole series. Or there'll be an email coming out sometime in the next couple of months so that you can sign up for that. And hopefully that's useful and enjoyable for everybody. Thank you all for coming along.
See you at the next one.
Yeah.